Κυρίες και κύριοι, καλησπέρα. Good afternoon, ladies and gentlemen. On behalf of all the colleagues at our Lex Forum Legal Journal and Sakulas Publications, Athens, Thessaloniki, we warmly welcome you to our 14th webinar, focusing this time on the legal frontiers of artificial intelligence. The use of AI in the administration of justice presents a fascinating challenge. Deploying AI systems in such a critical area must be characterized by transparent, explainable, and robust systems. These systems should aim to remove traditional bureaucratic barriers and enhance the processing capabilities of judges without compromising the rule of law and the fundamental rights. Exploring AI systems is also crucial for international civil procedural and international civil law due to the cross-border nature of AI's value chain from upstream providers to downstream users. The AI market is underpinned by a complex network of international relationships between key commercial stakeholders, including system providers, deployers, importers, and distributors. The cross-border provision of AI products and services for end users create significant potential for both contractual and perhaps most critically non-contractual disputes. These disputes may not only pertain to issues of civil liability, but also involve infringement of fundamental rights. In this context, it is a privilege that Lex Forum, in collaboration with the Department of Media, Communications and Technology Law of the Faculty of Laws at the University of Malta, is hosting today a webinar on the legal frontiers of artificial intelligence. The University of Malta is well renowned for its interdisciplinary exploration of emerging technologies, make it an ideal partner for this event. We are delighted to host three distinguished speakers from the University of Malta. Professor Joshua Ellul, Director of the Center for Distributed Ledger Technologies, who will provide an accessible introduction to the technological underpinnings of AI for non-specialists. Dr. Mireille Caruana, Head of the Department of Media, Communications and Technology Law, who will discuss data protection challenges in AI. And Dr. Ioannis Revolidis, Resident Academic Lecturer at both the Center for Distributed Ledger Technologies and the Department of Media and Technology Law, an alumnus of our own Aristotle University of Thessaloniki, which he provide an overview of key legal issues concerning general-purpose AI systems under EU law. Dr. Revolidis is the main connecting point between today's co-organizers, so today's event is largely credited to his efforts. Additionally, we are honored to have with us three world-leading legal experts: Professor Dan Svantesson from Bond University, Australia, and Professor Péter Mezei from Szeged University, Hungary. They will respectively discuss the relationship between AI and private international law and generative artificial intelligence and brainwashing. We also privileged to have Mr. William Valasidis, the Greek judge at the General Court of the European Union, who will elucidate the impact of artificial intelligence on the judicial process with specific reference to the Court of Justice of the European Union. We extend our sincere thanks to all esteemed speakers for the extraordinary honor to their participation today. We are especially grateful to Professor Svantesson, who joined us for the third consecutive year despite the inconvenient time in Queensland, where it is currently almost 1:00 a.m. I would also like to extend, on behalf of the entire team of Lex Forum, our deepest gratitude to Professor Svantesson for joining from this year on our editorial board His involvement is a significant honor and greatly enriches our journal. Before handing over to Dr. Mireille Caruana, who will welcome you on behalf of the co-organizing University of Malta, I would like to express our heartfelt gratitude to Professor Lilian Mitrou from the Department of Information and Communication System Engineering at the University of the Aegean. Professor Mitrou is the most distinguished academic in the field of artificial intelligence law in Greece, and we are deeply grateful for her willingness to preside over today's event. Please note that all attendees, we look forward, thank you all for joining us today. We look forward to a stimulating and insightful discussion. Please note that all attendees can submit questions to the panelists, indicating the name of the rapporteur to whom the question is addressed only via the Q&A function. Thank you very much. Please, Dr. Caruana, you have the floor.
Thank you very much, and good afternoon, everyone. So I would also, on my part, like to welcome everyone to today's Lex Forum webinar. I am Mireille Caruana, head of the department of, as I have been introduced, head of the Department of Media, Communications and Technology Law at the University of Malta. Our department is dedicated to exploring the dynamic and ever-evolving landscape of media, communications and technology law. I am delighted to be here with my departmental colleague, Dr. Ioannis Revolidis, who is from Greece, as we know, and brings a wealth of knowledge and international experience to our department. His expertise in digital law and regulatory frameworks has been invaluable to our research and teaching efforts. I would also briefly introduce, although he has already been introduced, but Professor Joshua Ellul, as said, director of the Center for Distributed Ledger Technologies and a friend of our department, who has worked significantly towards fostering close collaborative ties with our department in the Faculty of Laws. We are particularly pleased to co-host the Lex Forum webinar today. This event reflects our commitment to fostering dialogue and collaboration among academics, practitioners, and students in the field of law. Such interactions are essential for advancing our understanding and shaping the future of technology law. It is a pleasure and an honor to share the stage with such esteemed colleagues and experts in the field. Your insights and contributions are highly valued, and I look forward to engaging discussions that will undoubtedly enrich our collective knowledge. Thank you all for being here and contributing to this important discourse. I would now pass on the floor to Professor Mitrou.
Thank you, Mireille. Good afternoon. I must say that it's thank you for your kind words. I must say that it's a special honor and a pleasure for me to coordinate such an exciting discussion, such an exciting webinar, because already the title, The Legal Frontiers of Artificial Intelligence, is challenging. And I'm really looking forward to hear which are these barriers, if existing, and who will set these barriers, and how the law, the legal practitioners, but especially the academia, could contribute to resolve this issue. Are there barriers? Should be barriers to artificial intelligence, and how can we stimulate the discussion about this? I'm stopping here, and because we have really exciting speeches to hear, and I will give the floor to Joshua Ellul, who is promising to demystify AI. And what was already very interesting in my view was the fact that he, in a way, already in the title, he's connecting, he's combining artificial intelligence with the web, which is something that is not so obvious in the analysis that we, in many cases, hear. Professor Ellul, the floor is yours.
Thanks a lot. Thanks for having me, and looking forward to this panel. So you should be able to see my screen, and I'm going to jump right in.
I would like to ask you, it's clear to keep on time in order to have time for the other colleagues. As already said, for the questions will be posed, will be addressed to the specific, in any case, in any time, speaker, not in general. Try to identify the speaker that is addressed to. We will discuss about the questions at the end of the speeches, at the end of the webinar, with the exemption of Péter Mezei, who has unfortunately to leave, and William Valasidis, who has also to leave earlier. But we'll discuss about it. Please, Joshua,
Excellent.
Do your best to...
Indeed, I'll definitely try. I have quite a wealth of experience of dealing with my colleagues here from law, so hopefully I'll manage to get something across. Well, as we all know, we're hearing that AI will change everything, and it will definitely change some things, but I would like to ask how much of this technology is new and how much of the fact that it will change everything may actually be hype as well. And let's start by getting an understanding of the technologies, and then towards the end, consider some risks and how this may impact the future web. So really, if we take a step back to the early computational history, and we start with automated systems, if we look at early day automated systems, they were used for payment processing, for paying or for automating checks to be paid to employees. And we can see early accounts of even trivial check issuing systems where problems emerged. So there's this article from the 60s where it says, you've all read about someone opening his mail and finding a check for some gigantic, absurd amount, which would be fantastic if you would receive one, but not so great for the issuer. And we can see over the years, even trivial systems like this, trivial automated systems, have resulted in such errors. Now, what I'd like to highlight is the computational systems we've had in the 60s were trivial. The amount of computation, the amount of complexity that we could express was very limited. And even with such limitations, we had problems. And we're going to revisit what this may mean for AI. And this wasn't because, well, it was mainly due to the limitations of computational resources that we had back then, but it was also due to the types of algorithms that we were running. The types of algorithms we were running were limited to the programmer's knowledge and the programmer's access to information that they had. So very early on as programmers, we realized that we were limited to write software that was limited to the knowledge that we had as developers, or limited to the knowledge we could get access to. And early systems, let's say we're considering a fraud detection systems, or some system to raise alerts if there's some suspicious activity. What we would do is write code that would say, if there's a transfer from one account to another that's greater than some amount, then raise an alert. Or for example, if a client is transferring over 25% of their last paycheck, then raise an alert. So we were limited to this kind of logic. And very early on, we started to question, can we write software that goes beyond our knowledge as a programmer? So can we, as software developers, somehow write software where we say, I do not exactly know myself as a programmer what a suspicious transaction may look like. But could the system somehow detect what a suspicious transaction is and raise an alert? And that was the thinking that we were undergoing in the early 50s and 60s. And this is an oversimplification, but it helps to get the point across. So early proposals to get around this, let's say, the specific type of use case, were get many different experts around the world and have the experts come up with different thresholds for different average monthly income, for example. And we would build this huge system of expert knowledge into a system that would then use these rules, these heuristics, to determine what was suspicious, what was non-suspicious. And this is what we were working on in the 50s and 60s, and these were expert systems. Now, expert systems is just one type of artificial intelligence, type of algorithm, proposed in the 50s and the 60s. And we often say that AI is an emerging technology. Yet these types of systems were proposed in the 50s and 60s. How emerging are they? Well, we're starting to use them much more indeed, but the techniques that we're using right now are more or less the same as those proposed in the 50s and 60s. But what is artificial intelligence? So really, artificial intelligence is just a software algorithm, is just a software technique. And I say just not to undermine it, but also to highlight that, yes, it is just at the end of the day, a software technique. And we'll briefly introduce two types. Let's start with a fun way of depicting artificial intelligence as though we're going to play a game. You may have played Super Mario when you were younger. This may give you an indication of my age. And let's say that as a software developer, I want to write code to play Super Mario for me because I'm not very good at Super Mario, let's say. What I may do, and this is what software developers would first try to do, is say, how can I write the input sequences for the controller or the input sequences for the game to beat Super Mario? And I may say, well, okay, I know I've played this level before. I'll make Mario run forward for a few seconds, jump on this Goomba and keep going forward. And I would map out all of these different inputs over time. However, if I were to write code like this that has the explicit inputs to beat the level, I would need to write all of the inputs to beat all of the levels, and that would take a lot of time. So what I am currently trying to do here is beat this game with code using my knowledge of how to beat it. Now, using AI, we question, can I write software where I do not rely on my explicit knowledge that somehow can beat this game? So one type of AI technique is just try random inputs. Try random, in this particular use case, random sequences of how to control Super Mario until he beats the level. And we just keep trying random inputs, and we keep the random inputs that allows for Mario, in this case, to go run faster, run longer, beat the level, and we discard those inputs where Mario dies. So this is what we often call in this space a fitness function. How fit is this algorithm at getting towards the final goal? And a fitness function, all it means is find a value that allows for us to evaluate how good something is. So if Mario dies very quickly, that's not very fit. Discard those random inputs. If we see that Mario travels to the end of the level or much further than other random sequences, then that is a better value of fitness than compared to what we said before. And we just keep doing this. We just keep trying random permutations of inputs and keep the better ones and discard the older ones. So this is one type of artificial intelligence. And as you see here, all we're doing is describing what is good and keeping the inputs that allow for us to achieve good, whatever good may be. So that's one type of artificial intelligence. And here we use the case of Super Mario, but let's get more closer to a professional use case and another type of artificial intelligence. Another type of artificial intelligence relies on the fact that we have extensive amounts of data that can describe what is good and can describe what is bad. And given large amounts of data, of old historic data, we want to predict future outcomes, or we want to predict unseen data or transactions. So for example, let's say we go back to trying to detect fraudulent activity inside of payment transaction systems. Given banks having loads and loads and loads of data, what is good data, what are good valid transactions, and what are fraudulent transactions, they can create a data model describing what legit legal transactions look like and what the more fraudulent ones look like. Once we have this model, we can then just put and pass in any new transaction into the system and classify how similar it is this new unseen transaction to a legal transaction or a fraudulent transaction. And this type of training data to create the system really defines how good the system is. At the end of the day, it really defines how good our system will be at detecting a legal transaction, a legit transaction, or a fraudulent transaction. So here we're seeing that these types of algorithms that we're writing, where the code could be 100% correct, could have different outcomes based upon the type of data that we're feeding into the system. And this is crucial for us when we're creating AI systems to ensure that we are feeding in data that will allow for the system to correctly classify and not incorrectly classify a transaction. And there's other issues as well, where we could end up introducing certain biases into systems that we may not want. For example, we may see that if we have an unbalanced data set, that certain individuals from certain demographics may end up having their transactions failing more than others, just for example. So this is a very big problem in AI. However, when we talk about artificial intelligence, one particular thing we need to really consider is, what are we specifically talking about when we say artificial intelligence? What do we mean when we are trying to regulate AI? What are we specifically talking about with respect to AI? And this is very important in the discussions in AI. Are we talking about AI, the algorithm, the software that I just discussed? Are we talking about, and if that is what we're talking about, that we're talking about an algorithm, are we just saying statistics? Because essentially that's what artificial intelligence is, just statistics based upon previous data. Or are we talking about the specific use of AI in a system? For example, are we talking about social media platforms or other types of platforms? And if it is the case, are we still talking about artificial intelligence, or are we talking about specific types of platforms? And if we are talking about platforms, and we are talking about platforms that use AI, then we need to question, should we only be regulating or providing certain guarantees because it uses artificial intelligence? Because it uses statistical models inside of it? And does that mean we should not have the same concern for systems that do not use these types of algorithms that I've just discussed? So consider, for example, an insurance policy system. Should we only provide guarantees on systems and the outcome of this insurance policy system to issue an insurance policy or not to an individual because it uses AI? And we do not need those guarantees for a system that uses a non-AI or a traditional type of algorithm? So these are the questions that we really need to factor in when we're discussing AI and the implications of AI and how to regulate AI. But again, AI is great, and we're going to automate so much in life using AI, so much more than we've been doing. And this then raises certain questions where we see news media articles and various people saying AI is going to take our jobs. Well, yes, we will be using AI just like we used factories in the past and software in the past to automate more, and that very may well take certain types of jobs or change certain types of jobs. And in fact, even in the legal sphere, we're seeing articles emerging where people are saying, could AI even automate some aspects of the legal sphere? And also accounting and even our programmers. And to be honest, I think as a programmer myself, as a computer scientist, I think it would be great if AI can actually replace me, because I cannot wait to be at the beach enjoying a cocktail. But unfortunately, I'm going to have to wait for that, because no, AI is not going to be taking our jobs to this extent. However, AI will be enhancing our jobs and allowing for us to do much more, given the amount of data that we have available. However, are we saying that we can just start to use AI and do away with our part as, let's say, programmers or lawyers and just let these systems run free? Well, if you look into various uses of AI over the past decades, and we have been using AI in the web for many decades, it is not anything really that new. We can see infamous cases where AI-powered recruiting tools unfortunately resulted in giving bias towards certain genders rather than others. And that's just an outcome of imbalanced data sets. And this is why we need to make sure that our algorithms are working correctly, but also that our data fed into these systems are working correctly. We see cases of where AI was used to track in a football game the linesman, and not the linesman, the ball, and the AI system mistook a particular linesman for the ball because the linesman was bald. We see cases of where automated vehicle systems end up changing lanes because of obstacles that were in the street. So what I'm trying to say here is AI is not perfect, and we definitely need some form of assurances when we're using these types of systems. Now, I would like to highlight that ultimately, like I've just shown before, I've mentioned two types of artificial intelligence algorithms: those that use random inputs and try to find a good outcome, whatever that good outcome may be, and those that rely on data. But ultimately, it is just software. It is just a type of technique of software. And we've been writing software for decades, from command prompt windows to OSs, to browsers, to mobiles, to embedded systems, and robots. And given our decades of history of writing software, we've gotten very good at writing software, and software just works, right? Well, no. We see that we have decades of bugs in software, from Windows crashing to our Macs spinning to browsers crashing and mobiles bricking, and even robots crashing due to bugs. Now, if we look back again to very early software, we see cases of safety critical systems that have very large amounts of money at stake, or or potential damage on equipment, or even material damage, or even loss of life. We see cases of trivial software that resulted in such issues. So the NASA Spirit rover became unresponsive after a few weeks of landing on Mars. And this was due to a software developer who commented out a delete routine, and they were just ending up having too many files on the system. The Therac-25 radiation therapy machine ended up killing at least 5 patients, the very same patients the machine was meant to help in their treatment. And this was due to, again, a software bug, and a trivial software bug. Here we were talking about hundreds of lines of code to a few thousand lines of code. And now we're dealing with systems of tens of thousands, hundreds of thousands, and just exponential amounts of code. But over the years, we've developed software assurances to make sure that we can write better code when we can find these bugs before they're used in public. And we have developer support tools that help us as developers, as we're writing code, to give us hints on where certain bugs may emerge. And we have testing frameworks, and I won't go into the merits of all the different types of assurances that we have, but we've built up a framework of many different types of ways of catching these bugs before they're actually in the wild. And the thing is, what we have, all of these different tools, what we have helps us. It's good, but is it good enough? And the question is, for most applications, when we're creating our web applications, where we have users coming onto our systems, and sometimes, most of the time they work, but sometimes they may fail. Very often for those types of systems, it's not the end of the world if there is a bug. However, for safety critical applications where there's potential loss of life, applications where there could be large financial losses, or have some impact on society or individuals at large, that is not good enough. And we need to ask, what is done in other industries? How can we raise the levels of assurances to make sure that these types of systems work correctly? So what is done in other types of industries, like aviation? Well, in aviation and other types of safety critical systems, independent audits are required to make sure that systems are fit for purpose. And this is one need that we have been highlighting over the past decades, that we need technology audits to raise the levels of assurances to, as much as possible, make sure that systems work. And we can never reach 100% certainty either. Now, the question that I'd like to pose is, given that I've introduced some infamous and very fatal bugs with trivial code, now that we're talking about AI systems where we know that the code may be working correctly, but the data could have some impact on the behavior or the outcome of the system, and that these systems are no longer trivial. Which AI systems will become infamous and added to the list of these trivial bugs? And ideally, it will be none. And this is where I want to now discuss how the future web may emerge over time. So let's assume that we are going to start applying some form of audit on these types of systems to make sure that they're working correctly, these AI systems. So an auditor comes, he checks the system, he says, it's great, the system seems to be working, the data seems to be well balanced, and it seems like this AI system will work properly. Now, as we do with software, we very often need to update our software. There's new features. We may find a bug and fix the bug. And any minor feature, any single change in code could have a drastic change to the actual full system, even though we didn't believe so. So the programmer makes her change, and rightly so. A lawyer, or let's say the legal framework, should mandate that if a change was made, you would need then to assure that the system is still correct, and we would need to check that system again. Now, this can incur a lot of costs. Now, what I'd like to just close off with is the fact that we're going to have more and more systems being created and more systems being released on the internet. Can we really provide the assurances necessary to make sure that these types of systems are working correctly? Especially now in light of AI systems like ChatGPT, where I can just ask the system, I can ask ChatGPT to create software and full software with a few single prompts, and it will output all of that software for me. Given that we were going to have the proliferation of AI systems and many types of systems available on the web, are we really going to have the ability to provide the assurances necessary? Given that now we can have 14-year-old kids behind their computer screens creating the new future web using these types of AI systems, can we really provide the assurances necessary? I hope that that provides a bit of an overview of what AI is and demystifies some of the hype surrounding AI, and that AI is just a type of software technique, and that this sets the scene for the rest of the discussions that we'll be having in this panel today. Thanks, everyone.
Thank you, Joshua. Your speech was really the proof that the discussion about AI must be only interdisciplinary. And it's extremely important that we try to know what we are talking about, because AI is 70 years old, but now it has become a buzzword. And many of us do not exactly know what they are talking about and what they are regulate for. And this is very important, because we must identify the issues posed, the problems posed, the challenges posed. And what was extremely important, what was very interesting at the end of your speech was this question: if can we be sure about the assurances, the necessary assurances that have to be provided? And what is also very important is to underline for the next for the discussion afterwards, is the need to have qualitative data. The quality of data is also very important, and to keep in mind that neither the humans nor AI is perfect. And with this word, I would like to pass the floor to Dan Svantesson, who is spending his night with us, actually. And he's a professor at the Faculty of Law at the Bond University, far away. And his speech will deal with AI and private international law. As we all know, that there will be, of course, disputes on national, international, and international level. And we are looking forward to hear about. Please, Dan.
All right. Thank you very much. I imagine you can see my screen now.
Yes,
is that correct?
Yes. It's
excellent.
Clear.
Thank you. So I'm going to talk about, I've been asked to talk about AI and private international law, and I'll do that from two perspectives. The first and most obvious is, how does private international law regulate AI, and what challenges do we face in that setting? Again, like Joshua talked about, how much is just hype and how much is real challenges. That is the first part. The second part will go into something I wrote about in 2019, that is, can AI help us solve some of the private international law issues we have in relation to the internet? And that would be a briefer part, but still something we'll cover. To set the scene, I think we need to start by reflecting on what are the challenges then when we apply private international law online. And I want to pause here and say two things. First of all, I shorten private international law like this, PRIL. So that's, when you see that in the slides, that's what I'm referring to, private international law. The other thing I want to say is, as was pointed out before by Professor Mitrou, AI is not only going to be, or is already not only an issue for us online, and I think my focus will be on our online side, but of course AI will raise lots of private international law issues potentially also in a more physical law dimension. But when we look at the online environment, the sort of challenges we face when it comes to private international law are primarily what connection factors justify a claim of jurisdictional law. So how do we link a certain legal claim to a particular jurisdiction and a particular law? I think that is the first challenge. It's a challenge that we still have made remarkably little progress on, despite the fact that we've been working on this sort of thing for a lot of years. The second one is then what we might talk about as spillover effects. If we have claims of jurisdiction or of application of law online, they often go further than maybe was intended, and definitely further than what was reasonable. So a lot of different countries might be affected, even though the country claiming jurisdiction or claiming the application of their law only had the right to do so in a more limited setting. So that's one thing. Related to that then is the issue of how do we deal with overlapping claims of jurisdiction or application of law. That's very common in the online environment, and that's the concern that I'm trying to address then when we talk about how AI might potentially help us in relation to private international law. I've used the term hyper-regulation in the past because I talked about how the regulation online oscillated between under-regulation and over-regulation, and then we headed into something with a crazy amount of laws applying to us that we might not even be aware of. So when I use the term hyper-regulation, I talk about a situation where there's a greater number of laws claiming to apply to our conduct than what we possibly can sort of absorb and comply with, and that at least some of those laws have a realistic potential of being enforced against us. So competing claims and overlapping claims is one thing, but then we still have also gaps. Sometimes no country's laws or jurisdiction applies to a given situation, and that also raises concerns. Fifth, we can talk about what level of cooperation can we expect between states. The traditional form of cooperation when it comes to private international law is, of course, in the form of recognition and enforcement of foreign judgments, but that's been a big challenge in the online environment given the different laws that we all have. And sitting in all of this is the issue of what role should and are the internet intermediaries playing. So all these challenges apply equally to AI situations. I don't think, given that private international law is generally aiming to be technology neutral, in some ways there is not so much new. We end up often with the same search for some sort of location that we can attach activities to and so on. And perhaps the more that AI can do, the more AI becomes like a human in output, the more we're going to see that the issues are the same as what we faced before. But if we try to identify some challenges, and there's very little, to be honest, very little written about private international law and AI. But if you look at some of the literature out there, we try to find aspects where AI is bringing something new to private international law. And I don't think there is much that has been put forward in that setting. Of course, AI can complicate things like identifying who do we take legal action against, and that might become even more complicated with things like decentralized DAOs, decentralized autonomous organizations and so on. but generally, the more complex a product is, if something goes wrong, it might be harder to identify who is to blame. There is going to be issues around contract formation and contract performance. Again, searching for a location for these sort of things where the contract has some sort of AI involvement. It is going to be a challenge, but it's not a new challenge because we faced it in different settings before. Same thing with targeting. If you think about the consumer protection setting in private international law, might require that the supplier has been targeting a certain jurisdiction. How does that play out in an AI setting? New twists, but same old issues. And the same thing with non-contractual wrongs. This continuous search for a location, often leading to some strange applications of legal fictions, is going to continue. So that's really not necessarily so much new. One area that's gotten a lot of attention is in the intellectual property area, where the data is being scraped and used for training AI, and questions arise around copyright and so on. And the Getty Images case that is ongoing in the UK at the moment is a good illustration of that. Their Stability AI was said to have been scraping images from Getty and using them to train AI. The question was whether or not Stability AI could be sued in the UK. That was one of the key questions, certainly the key questions from a private international law perspective. The court has only at this stage said it's something that needs to be heard properly, couldn't be dismissed on a sort of summary basis. So those sort of issues, where does training take place and so on, that's going to be raising issues. But I would say this, and this is sort of putting focus on the next presentation that is directly on intellectual property. Perhaps it could be said that it is not so much that we're finding issues in private international law. The issues that we're facing here are complications in this case, copyright law. So I think the solutions also for this sort of thing needs to be found in the substantive area of law, of copyright law. Because if you look at private international law, and I'm taking the federal court rules in Australia as an example here, there's certainly plenty of basis for claiming jurisdiction in the type of situation that we're talking about in this UK Getty Images case. So the question is just whether or not copyright law want to commit to making this sort of activity a wrong, and as long as that is done, then the grounds of jurisdiction that I put out here, many of them could be activated so that private international law works properly in this sort of setting. And I mention here, just to take one example, if a proceedings is founded on a tortious act or omission, in respect of which the damages was sustained wholly or partly in Australia, there I point you to a case that I discussed a year ago when I had last had the privilege of presenting here, where we had a case where a company in Australia could take action against a trademark registration in China based on that being an intentional infliction of economic harm by unlawful means. I'll ask you to have a look at that case from the publications from last year, because that shows a way around treating this sort of training scenarios just under copyright law as well. But as you can see, and point J here, for example, if there is a breach of Australian copyright law, the court can claim jurisdiction. So it's not so much a private international law issue in some ways. What is interesting, though, and I think where we run into more interesting challenges, is the obvious fact that AI has led to AI regulation, and AI regulation interacts with or impacts on private international law. It's an obvious thing to say, but I think that's where we'll find most of the interesting issues. And of course, the most famous of AI regulations is the EU's AI Act. I'm not going to go into it in detail, but obviously Article 2.1 in many ways is a private international law type provision, just as Article 3 is for the GDPR. And focus here could be placed on, for example, the regulation applies to the providers placing on the market or putting into service AI systems or placing on the market general purpose AI models in the Union, irrespective of whether those providers are established or located within the Union or in a third country. Clearly, the extraterritorial grab of control in a very much a sort of way that private international law might otherwise cater for. The one I found most complex here is probably C, that says that the regulation applies to providers and deployers of AI systems that have their place of establishment or are located in a third country, so non-EU based ones, where the output produced by the AI system is used in the Union. The rationale for it is clear and fair enough and all that, but I think it can end up going quite far. An example I used elsewhere is, imagine that we have an AI system outside of Europe that is used to generate new sounds that can be incorporated into music programs and so on. That would be an output produced by an AI system, and it might end up being used in the Union. And it's a little bit odd that then the regulation would be applying in that sort of situation. Of course, it's quite a harmless type of use of AI, so there might not be any real issues. It's certainly not a high-risk thing, but it's still, from a private international law perspective, shows that this can end up being quite a broad thing. I should also mention Article 22.1 of the AI Act that is now limited to high-risk systems. That's good, but it demands that prior to making their systems available in the Union, providers established in third countries shall be, by written mandate, appoint an authorized representative which is established in the Union. I think this is problematic in that if I've said this before in other settings, we can talk about this as rep localization. If every company acting online needs to have a representative in every market they are active in, it won't work. And the EU has, since the GDPR, tried to justify this by reference to some sort of leveling of a playing field. But if you think about the burden for a Swedish company to have a representative in EU, there's none because it's already based there. If you have an Australian company wanting to be active on the EU market and has to have an authorized representative in the Union, that incurs a cost. So it's not about truly a level playing field. I think the EU should drop that line. I'm fully on board with a sort of issue of effective protection, but that's probably where it all sits. The reason I mention that is it's important in relation to private international law too. First of all, I should mention that obviously as we're seeing more and more harmonization as to the substantive rules for AI regulation, as we see from the Council of Europe's Convention and the EU Act, in a sense, any harmonization of law undermines the role of private international law, since which law applies becomes irrelevant, right? If the law is the same everywhere, it doesn't matter which country's law is applied. So that's one impact, and I'm not saying that's a bad thing at all. Similarly, we can then say provisions like Article 2.1 of the AI Act or Article 3 of the GDPR that undermine the role of private international law, in that they are, in a sense, rules of private international law, even though they're not portrayed as such. So they compete with private international law in regulating the application of the law. Also, the Article 22.1 undermines the role of private international law because it ensures enforcement. It means that we don't have need for cross-border recognition and enforcement, in a sense. So that's another interesting one. Now, the differences in approaches, because there's still a lot, if you look internationally, there's still very different approaches to how we regulate AI. And because they go to core issues of society, it could be possible that we see more applications of public policy exceptions in the private international law context. And of course, choice of law becomes important in that setting, very much so, if you have substantially different rules. The bigger issue here, and I think what we can talk about, the systems complexity, or I try to be witty here and combine law with obesity, come up with law obesity, which is the problem we're facing with a lot of online regulation in Europe, not least now. Private international law rules are part of a bigger system now made up of the AI Act. We're going to have the AI Liability Act. We have the GDPR. We have still, never forget about e-commerce directive, Article 3.2, talking about sort of country of origin. We have national laws, international treaties, the fundamental rights that always comes up, and the DSA. What we are ending up with as we get more and more detailed regulations, as we get through the AI Act, we end up with a very, very complex system, and the private international law rules, the traditional ones, only form a part of that, and things are getting quite complicated. Now, if we're looking towards the future, and that's of course always dangerous, perhaps there is a possibility of convergence. I'm not going to go into details here in the interest of time, but I had talked about in the past something I called market sovereignty, and in a sense, we're seeing some thinking like that in the EU Act. It talks about if you place something on the market, then in a sense the law applies. Output produced by the AI system used in the Union, and so on. I'm not claiming credit for those wordings, and I'm certainly not taking responsibility for those wordings, but I think we can see that as part of a bigger trend, because in Australia we see more and more focus on what has been called the carry-on business test, which is quite similar, focused quite broadly on are you on the market or are you not. And of course, if you think back to the US minimum contact test, which goes back to 1945, so nothing new at all, it also has more of that sort of are you present on the market feel to it. So perhaps we are heading towards a convergence of how private international law approaches issues like AI regulation. But we need safeguards, and I don't think we have that yet. I flag here the need for something like forum non-convenience, but more broadly, if we link this, I get 2 more minutes and I'm done. I think this fits well with a framework I presented in the past, that's focused on whether or not there is a substantial connection to the state claiming jurisdiction, if there's legitimate interest. We're seeing that through this sort of are you on the market or not, but they're still missing the balancing with other interests. So where safeguards are still missing. So the last thing that I want to finish with then was this. Back in 2019, I published something in a short form online about how we could apply private AI to help with private international law problems. Because what we face online is often a situation where multiple laws apply to us at once, and we do not have the tools always as internet users to understand how those laws work as a system towards us. So I think that AI could help us in that respect. To get to that, we would need to start mapping out and sort of making models, computer-readable models out of private international law rules. Other scholars have already started on that. Then we have to make sure that we have the data of the different countries' laws and then feed that into a suitable system. Now I'm certainly in the territory of hype, because we are very far away from succeeding with anything like that as of yet. But I think that is an interesting aspect, that AI can actually help us with some of those issues. I will stop there in the interest of time.
Thank you, Dan. It was really very interesting presentation, and I must say that it reminded me of this discussion, this continuing, never-ending discussion about jurisdiction of internet and location and what is done, what is we understand under damage, etc. It's really very interesting, and I would like also to say that you have mentioned all these legislation on national and then multinational or international level, and I'm wondering, and you have also discussed about hyper-regulation, under-regulation, over-regulation. I'm wondering if every new element, every new legal element, legal instrument adds on complexity. And I'm afraid that the problem of consistency and concerning also how we can find a field of convergence will become very difficult and very complicated. And we must take also into account that not only AI Act is there, but also the AI Convention of the Council of Europe, which is open for ratification also to countries that are not member of Council of Europe. And perhaps it may serve as a kind of common field of discussion or of convergence of laws, but on the other side, I'm afraid it's the kind of the lowest common denominator. But it's another discussion, and I don't like to monopolize the discussion with my questions that have been raised due to your intervention, the intervention also of Joshua. And I would like to give now the floor to Péter Mezei, who is professor of law at the Faculty of Law and Political Sciences at the University of Szeged. Szeged, is that okay? Approximately. You can say it better, I'm afraid. And Péter is going to present us his views on generative AI, which is the new buzzword, okay, the new hype, and brainwashing. I'm looking forward to understand what do you mean with brainwashing. I'm sure that it would be something very interesting. Péter, the floor is yours.
Thank you very much for this introduction. I mean, Lilian, don't believe Hungarian language is easy, so you didn't really make a big mistake there. My hometown is called Szeged, but it's just a tiny thing. Let me add, or let me start my presentation with, of course, a big thank you for the organizers to invite me to give a talk on your event, which I know has its own history and tradition because of I already had the privilege to stay in Ioannis's home and look at Lex Forum, one issue of Lex Forum, which was about one of your earlier events. So I truly appreciate to have a chance to speak to you. And I just checked the number of participants. I'm literally shocked that I speak to more than 100 Greek people. So I hope you will like what I do now today. I have a few disclaimers. The first one is that I don't have slides. I have a good reason for that. Actually, two reasons for that. The first one is not simply that I'm lazy. It's, of course, I'm not lazy, but because this is such a fast-paced topic. Second, the real topic I'm going to present to you today is very much a thought experiment to me yet. I couldn't, honestly speaking, I couldn't really position my talk in copyright and AI research yet, and it would be highly problematic for me to really put it into a presentation. I didn't ask ChatGPT to do that instead of me, so all these words are coming from me. At least I think Ioannis can confirm that this sense of humor is really coming from a human, a very bad sense of humor from a very bad human, but in any case. The second thing is immediately two reflections. I really enjoyed Dan's presentation here, and I have my own opinion about AI Act. I do my research on copyright and the extraterritoriality that this regulation will have on copyright law. I really learned a lot from you. But the other thing I wanted to flag as an introduction is Lilian's word. She said just a few minutes before that we have to look at AI in an interdisciplinary manner. No question, this is really the future if we are looking for right answers, not just answers, but right ones. But this is a starting point for my presentation as well, because whatever I'm going to speak about today was first presented in Hungarian language, actually, only 15 days ago in Hungary on a media law conference. So this was really a real challenge to me. How should I talk to media law people about generative AI? And actually, I decided to speak about how generative AI companies communicate. or that was the starting point. How do they communicate about their activities as regards generative AI and copyright law? So I tried to merge everything into one single presentation. And Lilian, so here is the answer, the magic answer. I know that the term grain washing is crap. I have to give up using that term because grain means something else. But I'm talking about greenwashing. Greenwashing generative artificial intelligence in the field of copyright law through regulatory, technological, and communication manners or activities. You will see at the web, actually, I mean, in the main part of my presentation, what do I mean by this? But since then, since I gave you the title of my presentation, I think I came up with a better idea how to call my whole talk rather than simply brainwashing. It means nothing really. I would call my presentation and probably my paper in the Lex Forum as From Strategy to Extremism, Greenwashing Generative AI. You will understand what I mean by from strategy to extremism, because I will try to show you examples how generative AI corporations have set up their strategy as regards to copyrights, how they have started to use various tactics to make their life, their survival more possible, and how did they reach the field of extremism with various claims and various acts as regards copyright and generative AI. I think this is, again, a thought experiment, but a lovely field, and to talk about even for copyright lawyers. My presentation starts with a very short summary here about the question, why is it important? Why is it timely? Why is it relevant for us? I mean, we already heard it from Joshua that AI is decades old story. Generative AI isn't, but of course, it's one of the new features. So it's the feature of artificial intelligence of our day. But why do we have that? I mean, there are various reasons, but in my humble understanding, we can spot 3+1 reasons or name 3+1 reasons for that. The first one is that currently it's at scale, it's big. It's not only an experimental thing anymore, but it's a business, actually, monetized commercial activity. Anyone can use ChatGPT and the image generators, and it's nothing about experimental AI projects like the Next Rembrandt anymore. Billions of people use ChatGPT and other services out there, which is definitely a different challenge that we had ever before. It's a different challenge, and different challenge at a different scale, consequently another fascinating copyright question. Next reason, platformization. The major players of the field are platforms. Not only, I know, I already had disputes about that with people from big corporations claiming they are not the only ones there. I know, but I love the argument that the New York Times reporters or journalists have stated at some point, who argued that on the long run, only big corporations can pay the bills, which is honestly true. First, it's very expensive, which means that the threshold to enter the market is high. Second, at some point, many startups and many stronger corporations alike, we run out of cash. And then comes mergers and purchases of other corporations. And ultimately, just like in every single field of business, we will have a few, not a lot, but a few market players out there. And by the way, they are predominantly platforms. So Google, Microsoft-backed OpenAI, Meta, Amazon-backed corporations, etc., etc. And why do I mention these platforms have a different logic? They have a different mindset. They have a different collection of goals, including money, not only, but including money. That's a big thing. Third, datafication. I call it datafication because I honestly believe that we know data is the basis of everything, but we are also in the stage now to be able to collect data at a massive scale, in an amount which is unprecedented. But just look at the AI Act. The AI Act classifies general purpose AI models that have over 1 billion parameters. I know I shouldn't be rude, but I'm just laughing on this. Nowadays, we are not talking about billions anymore. We are talking about trillions. So honestly, any AI models that have not 1 billion parameters are, just nuts. They are nothing. So honestly speaking, it's a big business, of course, but it is very data intensive. But we are definitely able to gather data. It's a thing. And all these came together. And of course, with these interests and issues in a single time, in a single place, we have generative AI. Plus one more, which I'm not digging into details at all, but that's the geopolitical dimension of generative AI. There's a real AI race, a rush to regulate, to control this field. I'm a copyright lawyer, so my major focus would be starting point, I mean, for any kind of discussion would be, is it copyright relevant what generative AI corporations do? This is the part that I'm honestly speaking skipping at this point because I already published on that. I will in the Lex Forum, if needed, certainly develop it in 1-2 pages. But my take is that the current technology is necessarily built on a certain form of reproduction, which is, I mean, again, a thing to discuss by copyright lawyers, but the reproduction right is a very broad concept, both in Hungary, the European Union, in the United States elsewhere. And we also have empirical evidences that generative AI applications do certain form of reproductions, be it only memorization or be it a longer run storage of information. Of course, and I will mention that very soon, this argument is contested by some generative AI developers or corporations. And of course, judges must decide on that. But my take, for the sake of clarity and for didactic purposes, is that there is a use out there. And that's the point. If that's a use, or there's a use, and there's a copyright relevant activity, that generative AI corporations must react on that claim. They must reflect on that and come up with hypothetically a strategy. So not only ad hoc solutions, but if they are smart enough, they have a strategy out there. And this is the point where I jump to my major argument of how generative AI developers try to greenwash, or in other terms, try to clear themselves and actually exempt themselves from copyright liability. And again, my major take is that the majority of the players have a quite clear strategy, which had to be reassessed in the course of time, and newer, tinier tactics were taken over and applied, not by all of them, but by some of them. And ultimately, quite recently, in the last few months, there are some kind of extreme arguments to defend their positions stronger and stronger, because actually the ropes are tighter. So their positions are not necessarily weakening, but they are under greater fire. So the strategic dimension of, the strategic arguments, and in my paper, I have a line for strategy. I would say I have 3 main blocks for strategic arguments there. Technological arguments, regulatory/legal. It's very loose because law is broad, but I would say, how do they try to regulate in their terms and conditions, and how do they regulate it through contracts? This is this part. And lastly, how do they sell it through words? I mean, how do they communicate? The technological strategy is very basic. There's no use. Their argument is that this is not a copyright relevant reproduction, nor adaptation, nor anything else. We are only learning information, transforming information into patterns which are not even necessarily copyright relevant at all. Indeed, the other very interesting technological strategy that they are doing is that they do not necessarily disclose information at all. What do they build their training on? Here I'm expressly talking about the closed and versus open data sets. Some generative AI developers are proud to say what are the sources of their models, and some are strategically remain silent as regards of their technology. I don't want to be rude here. We read a lot about the black box theory. I didn't list it practically here. I might list it at the communications dimension. But I know it from some people. You could also read it in articles quite recently as regards Anthropic. They argue we started to understand what's going on there. But it's a wonderful argument to say we don't know what's happening there. But it's just greenwashing what you are doing. We don't know what's happening, so we are not liable. We are not taking the responsibility for that. That's not nice. That's a basic strategy for them. As regards regulatory, legal dimension, they usually argue that, well, there are terms and conditions. Whatever is happening out there is based on contracts. You have to look at what we are offering to you because this is a service. We offer you a service. If you want to accept our terms and conditions, tick the box and take it or leave it. This is a very bright and clear strategy. This is just not honest in some sense. First, these rules are take it or leave it models, one direction, very general terms and conditions, average users, and even commercial partners have no words in that. As for copyright lawyers, there is, of course, one tiny issue there. How do they regulate the copyright dimensions of generative AI? Is there any copyright relevant output if you use, let's say, ChatGPT or whatever? These corporations have to reflect on that. And they usually, not always, but they usually say, whatever comes into existence is yours. Sometimes they say, why? Because if it's yours, responsibility is yours. Sometimes they say, proprietary interests come into existence and we transfer your rights or we keep those rights to you or we keep those rights. There are multiple solutions. I still remember Ioannis's presentation from on another conference in a slightly different topic, but I really loved his presentation about proprietary property. That was his word, how some terms and conditions reflect on what's happening through their services. And finally, the strategy as regards communication, again, maybe the black box, we can name it here as well. And the other one, which I love a lot, we are doing everything fairly. We fairly train our systems. The fair term has a big relevance here. In the United States, you might know there's a fair use doctrine. In the UK and some other Commonwealth countries, there is a fair dealing. Actually, even the Berne Convention mentions fair practices. So fairness is a magic keyword, it looks like. So communication-wise, the basic strategy is that we are fair guys. We are reasonable guys. We are the good pater familias. We are absolutely nice. Well, that's the surface level. That seemed to work for years. Still works to a certain degree, but life moved on. We have new challenges, new court cases, as Dan just mentioned, that there are court cases out there, not only from the UK, 2,000 from the US, other cases, China, Czech Republic, Germany. We have cases out there, so new reactions came. One of the tactics or tactical arguments as regards technology is that, but wait a minute, we are relying on open access, open source software as well, which is a lovely argument. Well, if it's open source, you can use it. The very funny and crazy thing at the same time is that some corporations, it's not an English term, but they create kind of secondary property rights based on open source content. That's greenwashing. They rely on fairly and freely accessible materials and come up with something which shouldn't be hypothetically theirs. The other thing which I wanted to flag here in the technology, but also leading us to the regulatory dimension, is opt-outs. There is this very important rule in the copyright in the digital service market directive as regards commercial TDM. Right holders can reserve their rights as regards TDM if they wish. We call it typically opt-out, although I think it would be much wiser to call it opt-back because you move back to the proprietary interests of yours. Anyway, what it means is that if you say no to TDM, generative AI developers must respect that and should stop using your source, whether they should remove your content from the data set, which is impossible practically, or whether they should stop using your source in the future. How you should express this reservation, it's a lovely thing. I worked a lot on that. I can cite it in my paper and you can find it online, but I just leave it there for a second. That's a nice tactic. Oh, well, we have our opt-out models. OpenAI says, Stability AI says, Bing says, Meta says. They have their own opt-out models. Whether they are effective, whether they comply with the laws is another question. But they have opt-out models. Oh, well, we are fine. We are washing our hands. Another thing which is quite fresh, I still don't have very deep knowledge on that. but I mean, on the latest one. But you might know that OpenAI signed contracts with Springer and most recently with News Corp, an American corporation. According to rumors, $250 million were paid for 5 years to have access to News Corp's journal articles, etc., etc. The only thing we don't know, what is this contract about? Is this a license to use the news articles or a contract for non-suing OpenAI by News Corp for using their data? I know it sounds silly, but you can contract on everything. And there are rumors saying that News Corp agreed against of millions of dollars simply not to sue OpenAI. You might say, oh, okay, what's with this? But the answer is that if it's not a license, then right holders should not get any money from the 250 million US dollars. This goes simply to the corporation. So this is not licensing copyrighted materials, but surviving licensing copyrighted materials. This is greenwashing your artificial intelligence model. Similarly, I keep it short, but similarly, indemnification. There is this brand new practice where Microsoft and other corporations indemnify their clients for the cost of a legal proceedings, if any, comes up. This is lovely. So Microsoft says that business clients shouldn't worry about attorney's fees. Microsoft will take it over. It sounds like a lovely activity, but honestly speaking, this is just like, all right, so if they take over the responsibility, then I do what I want. This is not cleaning the generative AI industry. This is truly just hiding the problems. This is why I call it greenwashing as well. And finally, tactical communication out there is something that OpenAI uses quite frequently. Others love to refer to that as well, but they say that the memorization of copyright-protected materials by OpenAI's technologies, GPT models, are a rare bug. So it's rare on the one hand, and this is only a mistake, a bug, a failure of the system. Well, oh, I love it. So if it's a bug, it's not a liability question. Of course it is. The fact that it's rare is not a problem. It is. But it's so fun. It's just a rare bug. Don't worry about this. This is greenwashing. But this is still not extreme. We are in the field of extremism currently, and I notice my time is practically over. Let me be very short with this. There is a technological and extreme argument out there. Not argument, technical activity out there. Transcribing YouTube videos without permission. We just got to know it from secret documents that OpenAI created an AI called Whisper to make transcriptions of YouTube videos, 100 million hours of videos or something like that, in order to have quality materials for further training without having any authorization for that. This is a clear reproduction. This is clearly illegal, but they are out of quality data. So they had to do something extreme. You might raise the question, why didn't Google sue them? And the answer is most probably because they did the same, similarly without permission. So if they would sue OpenAI, they would be in the same trouble. But guess what? And that's a regulatory extremism. Google changed the terms and conditions to get the permission from their own clients to get the transcriptions by them, not by others. But now they probably have the license to do that through the unilateral declarations in the terms and conditions. This is a very extreme argumentation, I would say, on a regulatory level. And my time is over, but just two more things. For communication, OpenAI expressly and openly tried to discredit New York Times in the famous recent New York Times case, where OpenAI said that that's not only a rare bug, what's there with memorization, but New York Times collected fake materials and cheated with collecting the materials for its Exhibit J in the application against OpenAI. So practically they say they broke the law to fight against OpenAI. Wow, okay, I mean, I don't say OpenAI are bad guys, but they say New York Times, the copyright holders are bad guys. Very lovely thing what we see. This is very extreme. And finally, and really last point, we have some information saying that OpenAI has erased certain documents that would have been necessary to understand what are the elements of the data sets that they were using for machine learning. And those workers who carried out those jobs are already out of OpenAI. They were either fired or they left the company on their own will. But anyway, I stop here. I leave it there, but I think that's quite a lot of food of thought. Again, saying the whole experiment, and I'm not judging here, so I'm not blaming anyone. I just simply say that the more we dig deeper into the development of OpenAI, the more extremism we will definitely see there. And I just say, I'm just a naive person. I don't like it. I don't like that we don't have a clear path, but a very dark path ahead of generative AI. I stop here. Thank you.
Thank you, Péter. Indeed, you have provided staff for many lecturers, webinars, conferences, because actually each of your argument was very insightful and very interesting and very provocative sometimes. But that was exactly what we are looking for, actually, for having such an interesting discussion. And I must say to all the participants, all the speakers that I have already messages that they find from friends that are participating to this webinar, that they find it already very exciting and very interesting, and one of the most interesting webinars that they have participated to in these issues. Actually, I could have a lot of questions also, and it was very interesting that this lack of transparency, which is actually a strategic choice, and and that brings me to ask not you, because as far as I think I can see that perhaps you have already a question to answer, but if we must regroup all this discussion and review all this discussion about intellectual property and data protection, etc., and think about it also in terms of of a new digital constitutionalism, in terms of kind of redistribution, review and redistribution of informational, and not only informational power, and of course actors like platforms, like all these companies, not only GAFAM, but also all these companies that are producing large language models, and they're using all this material from publicly accessible or not public accessible sources to bring us new services. I think we should discuss about this not only in every specific field, but also as a generic topic concerning how to redistribute obligations, rights, power, and whatever it means. And of course, I'd like very much your arguments concerning the fairness and fairly. And I must say that from my legal or even legalistic point of view, I'm not trusting such vague terms. I trust them only if they are combined with binding legal provisions, and they will be interpreted by the judge and or other authorities. Having said that, I must say that you have to leave, and perhaps you have to answer now if there is a question addressed to you. I have to see also here.
I have a little bit of time to stay, so I can, if people can just send the emails in the Q&A or chat, I will respond quickly. I have 43 minutes yet to stay, so
it's not a question, it's a confirmation about what I have said. Apparently, indeed. I mean, it is indeed a fascinating discussion. And okay, if there is no specific question addressed to Péter, I would like to give the floor to Mireille, who is going actually to discuss not a similar, but another issue about publicly available data and data privacy and use of scrapping in context of facial recognition systems. And I think that the common point between your presentation, Péter, and this of Mireille is exactly the use of publicly available information out there, either to use it for language models, generative AI or for face recognition for other purposes. Mireille, looking forward to hear you.
Thank you. Let me just see how to, okay. So I need to share my slideshow. That looks fine. Okay, thank you very much.
I can't see your presentation. Perhaps it's my problem.
No, I know what I did.
Now, yes, it's okay. We can see them.
Okay. So thank you very much for this very interesting debate and presentations. So indeed, I would like to talk about publicly available data and data privacy law, focusing on the case of scraping of facial images from the internet. So it was 2020 when the New York Times published an article which shone a light on a startup company by the name of Clearview AI that had trained a facial recognition system by scraping images from the internet. So the point here is that this company would scrape images, would analyze them biometrically, and develop a system which could allow for recognition, facial recognition. Now, this company provides its services to law enforcement authorities primarily, at least to date, and as far as we know. Facial recognition technology per se is not new. It was not new. Indeed, there are other companies. Another company which has been in the limelight has been a company by the name of Pimize that offers a similar service, except that it also offers it to the general public. So the awareness of these companies and of their training methodologies and training data sets gave rise to several ethical and legal controversies regarding the scraping of facial images from the internet and the inadequacy of current regulation to address these issues. So the legal controversies are clear if one looks at the amount of investigations that were carried out by data protection authorities in the European Union, and not only in the EU, but also beyond the European Union. And I just mentioned it very briefly that Clearview AI's methods have also been controversial even in the United States, despite the fact, of course, the data protection framework there is different and it's more based on sectoral legislation. I will discuss a bit later the fact that one of the issues here is the limitations of the law in this context, insofar as this company, and this links up, of course, with issues of jurisdiction, this company does not recognize the jurisdiction of the European Union to regulate it. So, as I said, similar proceedings, less of them, but similar controversies surrounding Pimize, issues that the company does not have an establishment in the EU, and in the end, I mean, some investigations were perhaps started, but never really got very far. Now, the thing about facial recognition is that the context in which it can be deployed are very varied. So it can go from something as basic as accessing your smartphone to border control, for example, and through rather controversial uses in the law enforcement sector to prevent crime, to prevent or to prosecute crime. So this brings up discussions, age-old discussions in the privacy sphere of privacy versus utility or privacy versus security, right? The trade-off between these. So it's hard to decide. I mean, Clearview AI, they actually use, this is a shot I got from their website. They think of themselves as the good guys, of course, and they boast that they have indeed a database consisting of 40+ billion images. So it raises the question, is this in fact a beneficial and socially acceptable service? Or rather, should we be concerned with the invasions of our privacy, and also the challenge to the presumption of innocence when biometric data is collected unlawfully and commercialized without our consent. So I took some time to think about really what do we object to when what is the problem? What do we worry about when we worry about scraping facial images from the internet? And the first thought I have on this thing is that when it comes to the large-scale processing of personal data, it can be difficult to pinpoint actual and concrete harm to an individual's interests. What I mean is that let us say that a company like Clearview AI has indeed scraped the internet for images, has my image on its database. It has not really caused me any harm. I might not be aware of it, but even if I am aware of it in a generic sense, at least, I mean, it's not so simple to point to what is the harm in this and why should this not be allowed. So authors have pointed towards structural and societal interests that are impacted. These are interests that are more subjective, and they are harder actually to demonstrate and to verify. So specifically in this context, people, when it comes to what is the problem, why do we worry about this scraping of facial images, people point towards the idea of knowledge and reasonable expectations. I recently had a conversation with a computer scientist, a friend of mine, who told me, like, if I put my image on the public internet, why should I expect to control what people can do with it? So indeed, I mean, perhaps we consciously make it publicly available. How should we and why should we expect to control it? Now, this made me think of an American philosopher's work that I have read, who speaks of something called what she has termed contextual integrity. And in her philosophical scheme, she says the violation of privacy occurs when reasonable expectations have not been met. Now, this to me links up with something that is present in our data protection laws in Europe when we speak about this term, which we have used in this discussion as well, fairness, because fairness links up to reasonable expectations. And reasonable expectations also link up to that there is a legitimate or morally justifiable norm. Now, this, again, this to me brings up thoughts that this links up law with ethics, really. And the ethics which underlie these social norms. So if one had to think, again, why would you object to your image being taken? The truth is that perhaps whether some people, I think many people actually cannot think why they should object. Privacy lawyers are, I think, a bit more primed to object to this kind of thing. But there's also the variable that ethical principles, I think, and social norms can change over time. So I think we should wait and see whether expectations change in time, right? So other concerns related to the creation of large-scale databases, the lack of a clear legal and regulatory framework, mass biometric surveillance. This has been termed like a perpetual lineup in the sense that the surveillance is indiscriminate. It is not focused on individuals who have been suspected of a crime or some. And then, of course, if one thinks of how these systems could be abused, secret government watch lists, we see lots of reporting about the potential of facial recognition being used to target political dissidents or ethnic minorities. And linking up again with the ulterior interests and the structure and societal interests, the undermining of democratic structures and with the so-called chilling effect. Now, to move on a bit from this, in terms of actually what the laws in Europe currently provide, if one looks at the DPA investigations of Clearview AI in particular, there are certain considerations which one could focus on. So questions about the material scope, the definition of personal data, special category personal data, which in particular includes biometric data, which is used for the purpose of uniquely identifying an individual. So indeed, facial recognition works on biometric templates called face prints, so it falls there. Issues of territorial scope, the GDPR, and I know this links up to things that Dan is very familiar with, of course. The GDPR will, in Europe, the GDPR claims jurisdiction if European citizens, if their behavior is monitored, if the behavior of European citizens is monitored. So the question is whether by merely scraping images, it is in fact a matter of monitoring the behavior of citizens. I'm not sure, convinced that it is, but it has been interpreted as such by our DPAs. The processing of operations, the collection and the processing of facial images in this manner, and the fact that this personal data is collected from a publicly available source. So as we're saying, issues of fairness, and reasonable expectations that an image that you put online will be biometrically analyzed and used in this manner. Transparency, the companies are not very transparent on their training methodologies or on their models. And in the European Union in particular, whether there is any lawful basis for this kind of activity. Then there's a question of whether the sanctions are effective. So far, we have seen sanctions consist of erasure, but this is not necessarily so effective if an individual data subject must bring a request for erasure. The high administrative fines also might not be so effective, especially if they are perceived as a cost of doing business. The company can pay a fine and still make much more profit. And what I think is a rather controversial element, which is whether there can be an order that whether it's possible to have an order requesting the erasure of the model that has been trained with the illegally collected and processed data. To the best of my knowledge to date, the FTC in the US has on occasion made this kind of order, but in Europe, to my knowledge, we have not yet gone there. And it's a question whether this could be an effective sanction, whether it could actually be deployed as a sanction. And here, of course, once again, as far as GDPR is concerned, the question of effective enforcement, as I said, in terms of territorial scope, the EU claims jurisdiction, but there is an issue, and this is something that was discussed in a recent paper co-authored by a panelist over here with us, which I thought was a very interesting paper, basically focusing on the fact that a company like Clearview AI, which refuses to cooperate with European DPAs, does not pay the fine and does not abide by the GDPR, does not therefore designate a new representative in the European Union. And in that sense, our laws can be totally ineffective. Now, more recently, of course, as we said, in Europe, we are very, very close to enacting the EU AI Act. We have a finalized version, I would say, but we haven't yet seen the official publication, the official journal. And again, I overlap with Dan's presentation, referring to the extraterritorial scope of the EU AI Act. If you look at this provision and think in terms of a company like Clearview AI, who incidentally, I should also say, are established in the US and have withdrawn from the European market. So they do not provide their services in the EU. So in that sense, when it comes to placing on the market or putting into service, they would not fall under the jurisdiction of the AI Act. When it comes to their output being used in the Union, I would suppose also it would not, the AI Act would not cover this company, not cover its activities insofar as the very scraping is concerned. Authorized representatives, as we said, there are none. And then I thought it was quite strange that the EU AI Act also applies to affected persons that are located in the Union. And I wonder if that could possibly, although I would doubt it, mean that the fact that my image has been scraped, has been collected, has been analyzed biometrically makes me an affected person. The term is not defined in the UAI Act, but the way it is used and the reciters and so on and so forth gives the impression that an affected person is someone who is affected by a decision of an AI system. So supposedly us in the European Union are not affected by the system per se. Now, the UAI Act also famously, I suppose, establishes this risk-based approach where there are a number of AI systems which are prohibited. And one of the prohibited systems specifically states that it is prohibited, what is prohibited is the placing on the market, putting into service for the specific purpose or use of AI systems that create or expand facial recognition databases through the untargeted scraping of facial images from the internet or CCTV footage. Now, this particular prohibition was not present in the original Commission proposal for the UAI Act. It was not present in the Council General approach, but it was introduced by the European Parliament when it established its mandate. To my mind, this provision seems to be specifically catering for the cases such as those of Clearview AI and PIMIs. I would think that there are perhaps two problems with this provision. The first one that specifically speaks of creating and expanding facial recognition databases. I think it depends on the AI system whether it actually does this, in the sense that my understanding is that, and indeed, PIMIs in particular does say this, that the company trains its AI model, but does not necessarily store the data it has used to train the model. So supposedly, if you are not effectively creating or expanding a facial recognition database, your database is the internet, effectively. But I don't think that's what the AI had in mind. So I suppose it would be one way to not fall within this prohibition. The other word, which I think may be problematic, is the term untargeted, which is also not defined in the UAI Act. And raises to mind, again, I really hope that if I'm saying something very silly from an AI perspective, Joshua will correct me. But if a system is trained to scrape images which have some parameters, some element of targeting, equal representation of male and female, equal representation of different racial backgrounds, would this no longer be a matter of untargeted scraping? So there are potentially ways to avoid this provision, is my point. Now, this is just to mention that one of the questions that crossed my mind when I was reading the AI Act and thinking about it is, how would we know how a company has trained their facial recognition system? And to the extent that the AI Act will be effective, the transparency requirements, which apply in this case because remote biometric identification systems are treated as high-risk AI systems. So a light is brought to shine on these companies that are obliged to draw up certain technical documentation. And in particular, this technical documentation includes information about the methodology for training an AI system, the training data sets used, the provenance of the data, and so forth. So my conclusions about this. Does the prohibition in Article 5.1e have an added value? It may have some added value. It is clear what it is prohibiting, but I think it has some serious limitations to it. As I said, whether the provision prohibits the activities of companies such as Clearview AI, well, it depends on how one is going to interpret this creation or expansion of a facial recognition database. And the last consideration I have here is that in terms of effective enforcement, you have similar weaknesses as those present in the GDPR, insofar as extraterritorial enforcement is concerned, and the similar representative localization requirement as found in GDPR. So my conclusions on this discussion: does the GDPR and the AI Act, does the legal framework in the EU protect us from the threats identified? Can data scraping of facial images ever be legal? My understanding is that currently the chances are that it is not. I would expect the data protection authorities to not in any way ever accept any lawful basis for this kind of processing. However, it is unclear, and I do think that, as we said, as we interpret terms like fairness and reasonable expectations, or indeed as ethical principles or standards may change in time, or social norms may change, laws may change, or the interpretation of laws may change. Because I suppose it is to be questioned whether indeed one should want to prohibit this method of training of a facial recognition system. It seems to me to be a bit of a contradiction in terms that these facial recognition systems are all often, one of the fears commonly expressed is, for example, the system is inaccurate and a person might be misidentified and might be wrongly arrested as a suspect for a crime, for example. So in a way, one might argue that if you want an accurate system, then using the best data set available, which is the open internet, perhaps is the way to go. If you forget about limiting the training of the system, right? Just accept that facial recognition is here to stay. It's already very advanced, and focusing merely on the deployment context. So if you do that, if you focus merely on the employment, on the context of deployment, then the next question to be asked is whether, in the end, this technology can be harnessed in a safe and positive way. Thank you very much.
Thank you, Mireille, for this insightful presentation, and provocative also in a way. Actually, it's very interesting. I was already always wondering if GDPR would be sufficient to face all these issues, and this prohibition of untargeted scrapping is a kind more of symbolic, let's say, because we have to interpret what's untargeted is and what is scrapping. And you have raised also the issue what is meant with database. If there is no database there, what should be the way that we have to deal with? Actually, one of the points was exactly the points concerning the fines. I think also that these fines imposed by the European data protection authorities have more a symbolic value, let's say, to underline that is not accepted, regardless the AI Act, that is not accepted. And I think that is one way to face or to deal with all these issues was if we can accept as a lawful evidence that is based on unlawfully trained databases or unlawfully trained models. And of course, one of the major issues in this case that we have also underlined, and I mentioned it at the beginning of your presentation, was the presumption of innocence. I think that this untargeted, generic processing of data, publicly available data, reverse this proof, the core actually of our system that not everybody is innocent, and makes us potential threat for society, or potential threat or potential criminals. This kind of untargeted scrapping of information, even publicly available, and what is meant with reasonable expectation is also a very important and question, because what is reasonable, what is expectation has also been influenced exactly by the technology that we have that is available, and by the use of technology. With the wide use of technological means like AI or like generative AI, that changes our perception about what is reasonable and what is acceptable and what is not. I could speak, your presentations are so interesting that I could really speak for hours, but I now have to give the floor to our next speaker, which will not be Professor Revolidis, but our judge, William Valasidis, as far as I can remember. William Valasidis, which is a judge of the Court of Justice of the European Union. And now we have to hear about the perspective of the judge who has to decide on all these issues in the final analysis. And could this judge be substituted by an artificial intelligence system?
That is a big question. Thank you very much. First of all, allow me to thank the organizers of this webinar for making me the honor to be here with you this afternoon or early morning in the case of our friend from Australia. First of all, I would like to clarify one thing. I'm not an artificial intelligence expert. I am not an artificial intelligence law expert, and I'm not here definitely not here to assess the adequacy of legislation, especially the EU AI Act, which has been finalized, will enter into force soon, and of course it will be upon the Court of Justice of the European Union and maybe also the General Court to interpret it. What I may bring to this discussion is my 26 years experience in judicial and administrative functions at the European Court of Justice, and my experience as a judge, which is relatively recent. The purpose of my presentation is to share with you the practical aspects of how artificial intelligence can accompany and reinforce the judicial process. And to that effect, I'm going to use the European Court of Justice as an example. I will structure my presentation in two parts. I thought it wouldn't be efficient.
Have you shared your presentation? Sorry for interrupting you.
No, I'm not sharing any presentation.
Okay.
I will be original in that respect. I could start explaining what kind of artificial intelligence applications the court is using or is envisaging to use in the future. Nevertheless, I think that would not be enough in order to give a complete understanding as to what is the current thinking at the Court of Justice of the European Union. In order to better understand, I thought that the first part of my presentation would be to give you an insider's view as to how a case is dealt with in the Court of Justice, in order for you to understand the needs of a court in terms of technology and how AI can help at various stages of the procedure. I will be, of course, very brief in that respect. Now, the life of a case before the court starts with the arrival of the application, which arrives either electronically or in some cases on paper. One has to realize that at the Court of Justice of the European Union, which is of course composed of two courts, the General Court and the Court of Justice, cases can arrive and must be handled and treated in 24 languages. So it is an integrally multilingual court. At the first stage, the court needs to understand what the case is about. So if we are all proficient in English in this group, so if a case arrives in English, that's really not a problem for anybody. Or if it arrives in French, which is the language of deliberations of a court. But if it arrives in Hungarian or in Lithuanian, the number of persons that can immediately understand what the case is about starts to become a bit more limited. However, the president of the court, or of the general court for that matter, they must very quickly get a grasp of what the case is about in order to be able to take initial procedural decisions and assign the case to a reporting judge. Then we have a written procedure. Written procedure takes place in the language of the procedure, which can be any of the 24. Nevertheless, member states can intervene in their own language, which means that the file of a case resembles a kind of a patchwork of documents in different linguistic versions. Therefore, translations are needed. Then we move on to the oral phase of the procedure. No, first before moving to the oral phase of a procedure, the reporting judge has to be able to read the file and start producing the first report on the case. To that effect, the reporting judge must summarize the legal issues and the arguments of the parties and propose how the case should be handled, by what type of judicial formation, 3 judges, 5 judges, 15 judges, and so forth, and so on. Then the judges altogether, including the advocates general, they decide on how the case should be treated based on the proposals of the reporting judge. And then we move to the oral hearing. And the oral hearing, we have the same linguistic requirements, meaning that the parties will be arguing in the language of the procedure. Member states will have the possibility of arguing in their own language. And then sometimes we have a common hearing with 2 cases that have different languages of procedure. So we have in the same morning, or maybe the whole day, listen to arguments not only in 2 or 3, but in 5 or 6 languages. Of course, in order to be able to do that, there's simultaneous interpretation. And at the end of the hearing, if we need to go back to what happened at the hearing and to refresh our memory while we are deliberating, then we have a recording of the hearing. And sometimes we can even request for a transcript to be produced, which up until recently was produced by the traditional method, typing. Then we move on to the deliberation phase. The deliberations of the court are secret and remain secret. So that is a challenge, as we will see later. And of course, once the judgment has been adopted, has been drafted, has been discussed, deliberated, debated between the judges, then it is not ready for publication yet. Why? Because, of course, the court, like I said, works in 24 languages. And the judgment has to be translated if it's going to figure to be published in the court reports. It has to be translated in all languages. Now, since a few years now, the Court of Justice of the European Union saw that in order to be able to function efficiently as a court, having to cover an area of justice of 450 million citizens, that it needs to be on the forefront and follow all the developments with regard to artificial intelligence in order to see how we can improve our efficiency and the quality in the administration of justice. Therefore, the court has developed an artificial intelligence strategy, which is summarized in a document that is freely available and one can find on the court's website. The court has adopted a governance model with at the top of the pyramid an artificial intelligence management board, where even judges are participating, and including representatives of our IT department and so forth and so on. And then we have other instances, lower instances, who are doing the actual work. We have an AI network with other institutions. We have an architecture board and data governance board, because of course, when it comes to AI, the quality of the data is of paramount importance. And there's of course a steering committee composed of representatives of all the services of the court that is following very closely all the applications developed. Now, what are the main objectives for the Court of Justice in using artificial intelligence applications? First, it's to improve the efficiency of administrative and judicial processes. Second is to enhance the quality of judicial decisions. And third is to enhance the access to justice and transparency. Now, with regard to the level of service that we expect from an AI application, we have three categories. First is cases where we accept some sort of automatization by an AI application, and that is when we want, for example, to extract metadata from documents of a case, such as keywords, etc. The establishment of an automatic transcript of the hearing that I mentioned, summaries, whether if we want to have summaries of our judgments for publication purposes, automatic automatic establishment of press releases on cases, and of course the big automatization bet that we are actually making for the future is translation. We do have a neuronal translation machine at the court. It is not there. It's not automated yet. It's not at the level that we would like in order to have a perfectly translated judgment, because judgment is a very precise text and every word counts. Nevertheless, it is definitely one area that we are exploring, and we expect a lot over the next few years. What we do not expect and we do not focus on is automatization of judicial decisions. We do not feel that this is something that the court has to pursue at this stage. Now, besides automatization, we are also looking at ways of advanced support in the judicial process. And there we have the tracing of the relevant case law, finding connections between the cases, and this is an application that could be very, very useful at the initial stage of a case when it first arrives, that would actually make the registry and the chambers of the president of the court immediately understand what the case is about roughly, and which are what's the relevant case law that could be at play there. Another means of advanced support would be summarizing scholarly writings. That, of course, concerns several of our panelists here. The judges at the Advocates General of the court do follow academic writings. Nevertheless, sometimes it is easier to have a summary in order to see whether that's an article that I'm interested in reading or it's very pertinent to a particular case, rather than having to read the whole big law review article of like 50 or 60 pages in order to realize whether it's important for the case or not. So having an AI application that would actually select scholarly writings and provide brief summaries of them is an application that we are envisaging. And then, of course, it is especially at the General Court, we sometimes have files that may be tens of thousands of pages, including annexes and evidence, etc. So an AI model that we are exploring is something, one that would actually be able to summarize the arguments of the parties in a more concisely, in order to get an immediate grasp of the issues of a case. And then we are moving to legal research, which is an obvious field where AI can be useful to a court, analyzing the initial action, whether that's it's an action for annulment or an infringement procedure launched by the Commission, or a preliminary ruling request by a national court. The research regarding the applicable law, the finding the applicable precedents, discovering all the relevant context. These are issues where an AI-powered search engine can actually be of extreme use to us. Now, then we move on to two areas which are a bit more problematic. It's deciding the case and justifying the judgment. Now, can we envisage, at least with regard to the Court of Justice of the European Union, AI decision-making? The international experience so far is mixed. On the one hand, we have applications that were actually used in the United States of America, such as the Compass application, which stands for Correctional Offender Management Profiling for Alternative Sanctions. It is basically a software that is destined to help the judges assess whether a convicted person is likely to be a recidivist or not. There has been very general critique of this proprietary software in the sense that the algorithms, first of all, are considered trade secrets, and therefore the public cannot examine them, and the affected parties cannot assess whether there's a violation of due process or not. That's one problem. Another criticism of such a type of software is that they are, of course, data dependent, as most AI applications, and therefore, if the data is biased, then the software will likely yield biased results. Therefore, this experience is cause for concern, let's say, from the other side of the Atlantic. Now, on the other hand, in Asia, we actually do have AI decision-making, especially as far as I understand in China. Nevertheless, one has to take into account cultural differences and different approaches and conceptions of privacy and personal data in order to assess whether certain things are possible or impossible on our side of the world. In any event, such applications are mostly done on minor disputes involving individuals, and this is really not the case of the cases that are brought before the General Court of the European Union or the Court of Justice of the European Union. I could hardly see an AI-powered judge or robot deciding about whether an individual should have the right to be dereferenced from the Google search engine regarding their personal data on the internet. Now, moving on to justifying the judgment, because it's one thing to decide and then another thing justifying this decision. There we have text, context, purpose, legislative intent, and legislative history. Now, AI applications can be useful when it comes probably to text and context, maybe legislative history, but when it comes to purpose and legislative intent, things become a little bit trickier. Moving on now to the challenges, because all of that is great. We do have some very good ideas about how we can develop applications that actually help the judicial process. But this is not at all easy. And the first challenge is that we are in the process of conceiving and establishing the red lines in terms of ethics and the ethical and philosophical red lines. We need to define where the judging begins and where the support to judging ends, and this is a very, very delicate line. There are also some pragmatic challenges in order to distinguish the phases of judicial decision making and determine those that can be computable or not. There are certain, of course, technical challenges, because ideally we would like to develop an in-house Curia internal AI brain, but that is extremely costly, and it takes a lot of resources, which brings me, of course, to the organizational challenges, meaning human resources and financial resources that one can dedicate to AI. Here I may open a parenthesis. Why are we discussing developing an internal AI brain? It's because of the secrecy of deliberations, and because there's a lot of data that is available to us internally at the court, but cannot be to an outside company that we would contract in order to develop something for us. And then, of course, finally, it's also the educational challenge, because the staff, starting from the judges, their immediate collaborators, the lawyer linguists, as we call the translators at the court, etc., they need to be taught and trained about how to use such AI applications. I will now share with you some final thoughts. I believe that artificial intelligence has tremendous potential in rendering judicial processes more efficient, more precise, and to contribute to a qualitative improvement in the administration of justice. Nevertheless, it is not a panacea. I believe personally that automatization possibilities are relatively limited, and we are not yet at the era of robot judges. And it would even be debatable about whether they should exist. Nevertheless, I think that courts must continuously follow developments and devote all the human and financial resources they have into pursuing applications that are appropriate to them. Now, of course, next to the courts, it's also alternative dispute resolution. And that is a completely different ballgame. And I believe that automatization can certainly be envisaged for mediation and arbitration procedures more widely. And with that, I will conclude, and I thank you very much for your attention.
Thank you very much for your presentation, for sharing your thoughts and your experience, which is also very valuable with us. And of course, it's one of my favorite issues, I must say, judge and AI, or AI and judge. And I should mention here that the AI Act, it's not favorable to decision-making by robots. I think recital, not very sure, recital 40 states that the final decision-making must remain a human-driven activity and decision. And of course, sometimes it's very difficult to differentiate between judging and justifying. I have not any experience as a judge, of course, but sometimes, and taking into account the cognitive capacities of an average judge, supporting also the decision by an AI system, by a database which is composed by data that are trained, etc., to support the decisions, may influence the decision as such. And of course, I share with you your question if it is the decision-making or the thinking, the human thinking is computable, as you have mentioned. And of course, you must keep also in mind that Cepes has also referred to this, that the use of such systems may be biased, or may be characterized of lack of accuracy, of inaccurate information, or information that may be misinterpreted in another context. I mean, we have also the EU law, which more or less the same, but on the other side, we have many the legal orders, especially in the EU, that they have their own context there, that every term has its own meaning. It's not comparable. The way we understand, for example, a term, the way in Hungary, the same term is understood and interpreted. Very, very exciting discussion, very exciting the thoughts that you have shared with us. And now I have to give the floor to the last but not least.
Can I before you give the floor, I have in front of my screen.
To leave, and perhaps you have
No. I have three questions. So shall I answer to them in writing, or shall I briefly answer them now?
You have to answer them now.
Okay, I will now. The first question that I see from Mr. Jellis is whether it is even possible for the Court of Justice of the European Union to ban mass surveillance at this point. I'm not going to give a straight answer, because these issues are decided based on specific cases that arrive before the court. But what I can say is that when we had the Google Spain case about the right to be dereferenced from the Google search engine, Google came before the court and argued that it's technically impossible to do. Turns out that it was very, very possible. Therefore, I think that it all depends on the kind of litigation that will be brought to the court, and one can be sure that the rights to privacy, as they are enshrined in the Charter and the GDPR, etc., will be fully enforced. And then I have a couple of questions from my very good colleague and friend, and one of the pioneers of IT applications in the law, Mr. Popotas. The first question is whether the European judge should become technically literate in order to judge AI Act cases and to interpret that particular piece of legislation, and whether the court should be assisted by experts. Now, what I can say about that is now it's not only the AI Act that is about to enter into force, but we also had very recently the entry into force of the Digital Markets Act and the Digital Services Act. And what I can say is that we, as judges, have already had several sessions of that training or information sessions in order to be introduced and to better understand this piece of legislation before any cases arrive. And I think that the same thing will happen regarding the AI legislation. And the last question is about whether the use of AI applications, that's a very good question, actually, in courts to assist judges in the assessment of cases, risks the consolidation of precedent, thus making the role of a judge to interpret restricted in the evolution of case law very difficult. I do agree that this is a risk, and this is why I do not believe in decision-making by AI applications. The human factor should already be there, because I see it very, very far-fetched to expect from an AI machine, let's say robot judge, to actually reverse a precedent and sense that the social evolution is such that a specific rule of law should be interpreted in a different way than it has been interpreted until now. So these are my answers. I hope I did not abuse of my time, and thank you very much.
Indeed, the last question was a very interesting one. And actually, the main question concerning the use of AI in the context of justice, I must say. And my problem, my thought about this is that indeed there's a threat that the use of AI may consolidate the past. And I would say prevent the evolution of jurisprudence. and the evolution of jurisprudence, especially, you have mentioned a very emblematic judgment concerning the dereferencing, not right to be forgotten, actually.
Well, the technical term is dereferencing, but I was director of communications at the time, and I insisted that the title of the press release be right to be forgotten, because otherwise
yes, from the point of view of marketing it's better, but actually, technically speaking, it's the referencing. And this was a case, another case also, that the court has proved that the evolution of the jurisprudence is very important exactly for the assurance of and the protection of fundamental rights in Europe. Thank you indeed for answering the questions, the interesting question for our participants. And now I will give the floor to, last but not least, I have enjoyed a lecture given by him last summer, I must say, and it was very exciting, and very exciting also to hear his thoughts, the thoughts of Ioannis also in this context.
Thank you very much, Professor Mitrou. Let me start with skipping the technical part, which is sharing my screen, so that you can see the presentation that I have prepared. Now you should be able to see my presentation.
We can see your presentation, okay.
Okay, excellent.
Yes, in case that you cannot see yours, perhaps you can share the other version that is...
okay.
Because it's
No,
important that you have also access to your presentation.
And it moves, right? You see the sequence of slides?
Yes.
Okay, great. So, yes, first and foremost, thank you very much for the introduction. And I would like to thank all the previous speakers for their very insightful presentations. This has been a very interesting evening, and indeed, lots of points that raise several issues to be discussed, as Professor Mitrou has already pointed out. Now, being the last one in such a long event, I will try to do the best use of my time in order to respect the patience that the audience has displayed staying with us in so long. And I will try to be focused and spot on. What I will try to do is talk about general purpose AI systems under EU law, but I need to make a disclaimer, and the disclaimer is that when I say EU law, I will focus mostly on the EU AI Act, and I will try to point to several issues that I see as relevant with regard to the DSA, but I will not expand to further areas of EU law, because EU law is, of course, a rather wide term. And when it comes to my agenda, in order to talk about general purpose AI within the EU AI Act, I'm obliged to speak a little bit about how did we come to the AI Act, because the history of this particular piece of legislation is important in order to understand the final form of the provisions. Now, secondly, in the second part of my presentation, I will try to explore how general purpose AI systems fit within the EU AI Act in the overall structure of the legislation. And finally, that is the part where I say that I will probably also mention the DSA, is that I would like to raise a few questions about generative AI and the misuse of content. Now, how did we come to the EU AI Act? Well, it all started officially, at least the legislative process that led to what we have in our hands today, started back in April 2021, when the European Commission thought, yet again, to make the job of IT law academics in Europe complicated by issuing another huge regulation. And the very beginnings of the AI Act are rather innocuous, in the sense that while the interest of the EU was not misguided, AI was around at the time. It was part of several applications. It has not yet entered the massive hype cycle that we experience now, and the massive hype cycle that was triggered during the legislative process. So in a way, the EU AI Act has fallen victim of the hype surrounding the technology around it. And why do I say victim? Because the hype has raised the expectations vis-a-vis the legislator. And this amount of pressure might not have been a good consultant for the final form of the provisions. Now, what is the origin? What is the regulatory DNA of the EU AI Act? Where did it all start? In the very beginning, in this very early draft proposal published by the European Commission back in April 2021, the EU AI Act was all about safety standards. So, in essence, AI was to be regulated, but it was to be regulated within a field of EU law that has to do with the safety and security of products. A very important part of EU law, but not the typical IT law, so to speak, that we usually have to deal with. In essence, AI was to be regulated alongside toys, medical devices, vehicles, and other such products. Not the least because AI was becoming part of such products. So that was the origin, that was the original idea. And by the way, there is something that I need to stress about safety and security law. It is an iterative process. That is an expression used in the AI Act, but I believe that it's more relevant than ever in the sense that when it comes to safety and security standards, we only become better through trial and error. And that means that there is a period of time where the products that are out, despite the standards, are not the safest. That we commit mistakes and we return with improved standards and so forth and so forth. So originally the EU AI Act was about this. But during the legislative process, of course, things have taken a different turn. Before I go there, though, there were some original key regulatory assumptions when the EU AI Act was first discussed back in 2021. The idea of the legislator on how AI distribution networks work and how AI is accessed by the general public made the following two assumptions. First, that there is someone who designs, programs, and trains the AI system, and someone who is in charge of its operations. There is, so to speak, an ultimate decision maker. This philosophy is still reflected in the text of the AI Act. For example, if somebody looks at Annex 3, where the AI Act is listing certain high-risk use cases for AI systems, this philosophy of having a principal decision maker, which is either an authority, a public authority, or a private entity that is deploying and using the AI system within its processes, is still existent. It's still part of the DNA of the EU AI Act. And a second assumption that was very important in the early days of the EU AI Act was that AI systems are relatively narrow applications in the sense that all they do is statistical inferences from a data set, and they can only execute a very limited amount of functions. Again, if one looks at how the EU AI Act understands high-risk AI systems, which is the more fleshed out category of AI systems in the legislation, one will see indeed relatively narrow use cases. For example, there are use cases that pertain to the use of AI only in employment, or the use of AI only in the administration of justice, which means that originally the idea was to regulate AI systems that were good at doing one thing. If I were to compare with what Professor Ellul said in his presentation, they look more like these early expert systems. They're very good at doing one task, but not other tasks. And also, within this assumption, the legislator also assumed that the main problem with AI comes from the data set, that the major risks associated with AI systems, apart from the risk level of the usage, mostly comes from the quality of the data upon which they are being trained. So that was, so to speak, these were the original assumptions. And as I said, these assumptions are still there. They are still reflected in the regulation of high-risk AI systems. But, and this led to the original pyramid, regulatory pyramid for AI systems, where the European Commission promised to classify under the AI Act AI systems in 4 main categories. The idea was that there are some systems that have unacceptable use cases. Today, we will see that in Article 5, that has still survived. that there are high-risk AI systems. There are several sections dedicated to them today in the AI Act as well. And then there are AI systems that are of limited and minimal risk. And of course, the regulatory burden for the deployment of such, the provision and deployment of such systems, it will depend on the level of the risk, right? Unacceptable risks are at the top of the pyramid because they were to be prohibited. High-risk systems would carry strong regulatory burdens and so forth and so forth. Limited risks, less burden, minimal risks as well. Now, while this was the original intention, there was a major turning point that general purpose AI became available to average internet users. That was back in November 2022. I mean, it's not the only application of that type, but I think everybody has heard ChatGPT by now. I think it is the application, the killer app, as people say in the tech argot that is being used in this context. This is how the legislator was now forced to react, because these systems bring with them a new set of challenges that were not originally taken into account when the AI Act was designed. For example, the so-called value chain of general purpose AI systems is more complicated than that of more standard AI systems and models. By value chains, we mean the distribution network. In essence, all the key stakeholders that are involved in the process of making AI available to the wider users. It is an expression commonly used in AI jargon, so I borrowed it to remain within the spirit. A second challenge that emerged and was not originally addressed by the original plan, the original draft of the EU AI Act, was that general purpose AI models and systems don't have a single intended purpose. These are systems that do not only perform a single function. In fact, sometimes they are even able to perform functions for which they have not specifically been trained for, which means that this original idea that, if we focus on the intended purpose, we're good, we're safe, was a little bit questioned. And of course, finally, and that is important, risks related to general purpose AI systems, as it has already become clear from all the presentations that presided mine, does not only come from bias or quality issues that are related to the data set used in order to train the AI system, but in essence, the risks are more or less unlimited in the sense, not only because of the fact that the systems can perform various different tasks, but also because they, in a way, allow more stakeholders to use them, and therefore to misuse them as well. To illustrate, to demonstrate, if we count November 2022 as the popularization of such systems, quite a few issues have emerged already. For example, people have a tendency to anthropomorphize, Greek word but complicated to say in English, AI agents. Apparently, it has been reported that some users have fallen in love with their AI companion. I never thought that I will see the scenario of the movie Her with Joaquin Phoenix become reality. Very interesting movie, by the way. I think it remains topical nowadays as well. I don't blame Joaquin Phoenix in the movie. If I had Scarlett Johansson in my ears 24/7, I might have had a similar reaction to him. Now, a second issue that we have seen related to such systems, these more capable systems, is of course the creation of deep fakes. I think by now everybody knows this infamous picture with the Pope who is dressed like Snoop Dogg. And although one can spot that this is a fake image, it can indeed create a lot of confusion. Now, to be honest, when it comes to this particular example, I want to show you something because my morbid curiosity took the better of me. I tried to see how ChatGPT would react in such a request. So I asked it to create an image of the infamous internet meme Péter the raccoon wearing a puffer jacket similar to that of the Pope. Now, I didn't, of course, say anything about whether the photo of the Pope wearing the jacket or not is true, but it seems like ChatGPT took it for granted that the Pope wears a puffer jacket, a white puffer jacket, right? And by the way, with a little bit more of engineering, the result was a little bit more convincing. As you can see, my Pedro is wearing a white puffer jacket similar to that of the Pope, and he seems to have on his head a papal tiara, right? So, you know, ChatGPT was not particularly capable in this case to recognize that, you know, everything stems from a deep fake. So it kind of reproduced another deep fake. Okay, apparently nobody would expect that a raccoon would wear a papal tiara or a white jacket, but, you know, in any case, the system indeed was not able to see that or see beyond that. Now, another issue, of course, is that the use of such systems has amplified the problem of defamation. It is widely known, I think, that these systems have a tendency to fabricate information, and sometimes this information will qualify as defamatory. Also, these systems have a tendency to give you advice on how to kill the Queen of England. And, of course, it has been reported that people have been able to manipulate the systems in order to create malware or biochemical weapons. So the potential risks of these systems are probably more complicated than those of the original systems that the EU AI Act aimed to address. So the legislator had to react. Therefore, there is a general purpose, there is a regulation of general purpose AI systems in the AI Act. But in order to make clear, for the purposes of my current research in this presentation, I'm working on the text published by the Council of the European Union, which I feel is going to be the text that we're going to see at the Official Journal. And in this text, as it was also the case, maybe already in previous iterations as well, there is something that we need to make clear. The EU AI Act differentiates between general purpose AI models and general purpose AI systems. Now, the EU AI Act only regulates directly with specific provisions AI, general purpose AI models, not systems. If there is a general purpose AI system, it's going to be regulated by the provisions that are applicable to all other AI systems. But the specific provisions on general purpose is focused on the models, so to speak. Now, Recital 97 clarifies that we should not mix the two terms, and it clarifies that the general purpose AI model is something of a more abstract product by comparison to the AI system. The model, in essence, is the mechanism that does all the magic under the hood. But for the average user to access it, it needs to become a system, because the system adds a user interface. Previously, for example, when I saw you how I manipulated ChatGPT to create a white puffer jacket for Péter the raccoon, I used an interface. I used the system, not a model. But the system gave me access to the model. So in essence, indirectly, I was manipulating the model. So as I said, the focus of the specific provisions within the EU AI Act focus on the model, not the system. Now, what is a general purpose AI model? Well, the definition lies in Article 3, paragraph 63. Yes, paragraph 63. There are as many paragraphs, in fact, even more. And the most important characteristic for these systems, where the legislator at least insists, is that these systems have display, so to speak, generality. To break that down a bit, the legislator characterizes general purpose systems that are able to perform different tasks. ChatGPT, for example, is such a system because it can do more than one thing relatively well. For example, ChatGPT can either help you write text, but it can also summarize the text. And therefore, it fits within the description of a general purpose system. And the model, of course, upon which the system operates will be a general purpose model. Now, the definition of the AI, general purpose AI system, is in Article 3, paragraph 66. And of course, such a system is based on a general purpose AI model, which has the capability to serve a variety of purposes. And of course, it can either be used directly or it can be integrated in other AI systems. Now, important thing, I want to stress that general purpose AI is not about the Terminator, right? Because at some point, it became a little bit overhyped, and so to speak, attention was drawn to the fact that, some people were claiming that the EU is regulating general AI intelligence. It's not, because it's not what the systems are doing, at least not the way I understand it. Now, The specific provisions on general purpose AI systems, of course, are tied to the general provisions of the EU AI Act, which means that whenever the EU AI Act does not apply, the provisions on general purpose AI systems or models will not apply as well. Now, there are some important exceptions from the scope that I want to mention here. The AI Act does not apply to AI models and systems that are used specifically for scientific research, that are used only for scientific research. And quite interestingly, the AI Act does not apply to the usage of AI systems, including general purpose, of course, models and systems, by natural persons for personal, not professional activities. Which means that when I created Péter the raccoon wearing a white puffer jacket, I was not really regulated by the AI Act. I was a natural person using the system for personal, not professional activities. I was mostly playing with the system. Now, moving forward, the EU AI Act puts together a range of stakeholders, but in reality, what you need to remember from that is that for whom the bell tolls louder, who bears the huge burden of the regulatory compliance, that would of course be the providers and the deployers of AI systems. Providers being the people that train, program, and so forth, and deployers being the people that put them in a professional use. Do you remember this original pyramid of AI risks? Well, forget it. The emperor has new clothes. This is how it looks like now that the text has essentially been finalized. In essence, the different categories of risks remain in general, but what the final text adds is, of course, at the bottom, the general purpose AI models. And I will return to that scheme just to demonstrate how they interact. Now, I have tried to summarize the compliance obligation for general purpose AI models. Okay. Now, of course, to go through the entire table, it will take a lot of time, and I don't have the time, but I want to raise an important point. The EU AI Act makes several categorizations of general purpose AI models which regulates. As you can see in my table, the general purpose AI models that carry the heaviest regulatory compliance duties are those that pose systemic risks as per Article 51 of the EU AI Act. If you want to see what an AI model that poses a systemic risk is, you have to look at recitals 110 and 11 and Annex 13. In essence, the legislator puts here systems that seem to have very strong computational capabilities. But if one looks a little bit closer at the recitals that I mentioned in the annex, the picture is a little bit more complicated because it's not only computational power that matters, it is a combination of different factors. If you are wondering who is going to do the assessment, unfortunately, is the providers themselves. Although the ultimate decision will lay with the authorities, first the providers have to decide and classify themselves whether they generate general purpose AI systems that pose systemic risks or not. And a small important note here, as you can see in the table, the level of regulation and the burden of regulation, of course, differs, right? While, as I said, general purpose AI models bear the strongest regulatory compliance burden, the heaviest regulatory compliance burden, there are, for example, on the opposite end, standard general purpose AI systems. So that is general purpose AI systems that do not pose systemic risks, that are free and open source. Why do I mention that? Because sometimes there is this misconception that free and open source AI is completely excluded from the AI Act. That's not true. It is still regulated. And when it comes especially to general purpose AI models, many of the obligations remain intact. Of course, some of the obligations are covered by the fact that the model is being issued in a free and open source manner, but the majority of the rest of the obligations remain intact. Now, as you can see in my table, in essence, the rules, the compliance requirements, I'm not sure that they address the majority of the risks that we have seen already by these systems. I mean that, by that I mean that we're mostly talking about documentation and transparency requirements. While such requirements, of course, are probably beneficial for the people that are deploying these systems downstream, or maybe some other users that want to assert their rights, the major risks, especially the problem of the misuse of content, is only partially regulated under the EU AI Act. Now, in the interest of time, because I don't want to play with your patience, I just want to pose a few questions as my last notes when it comes to general purpose AI systems and the misuse of content. As I said, one of the most important problems with these types of models and systems is that they can perpetuate the problem of deepfakes, misinformation, disinformation, fake news, and the such. Now, the AI Act in Article 50 tries to address this by at least forcing the companies to brand the content created using such systems as generated by AI. But I don't know whether this is going to be a fully effective issue. And when I turn my eyes to the classic legislative framework that regulates misuse of content in the EU, which is the DSA Act, I have a feeling that general purpose AI models and maybe systems do not seem to fit well within the categories of online service providers regulated under the EU AI Act, under the DSA Act. And most importantly, we have to remember that this content, like a deep fake or misinformation, is not necessarily illegal. While the DSA has a strong focus on illegal content, misinformation and disinformation are a little bit of an indirect issue there. So it's a problem that needs to be addressed with further research. Now, thank you very much for your patience, and sorry for exceeding a little bit the time, but as you can see, the EU AI Act raises so many issues that I could have been speaking about it for hours, and I would still not be able to cover everything. I hope I gave an overview nonetheless of how general purpose AI systems have been incorporated into the system, and of course, I'm open to questions and remarks. In fact, there is one question that I spotted which I think I might be able to answer because it fits well within what I was trying to present.
Thank you so much, Ioannis, for this. It was really a very insightful and comprehensive overview about the general purpose AI systems. And actually, to share one thought with you, it's the way that the European Union has reacted to this popularization of these models already existed in 22. It proves that we try to regulate in a technology neutral way, but actually we have a specific technology in mind. And I'm not very sure how achievable will be to regulate in a technology agnostic or neutral way, and it's really very difficult to keep pace with this evolution. And the generative AI is a very proof about this. And another issue that you have raised is this difficulty to have a consistency between the various acts, DSA Act and AI Act. For example, the terminology is different. It's not very easy to adjust the actors and the terms used in DSA with them used in the AI Act, and this will be proved to be a problem in my view in the near future. And of course, another issue that is that all the systemic risk is actually risk assessment is actually a self-assessment. Okay, to be controlled by the authority who will be in charge of enforcing the law, of controlling the enforcement of the law, but I'm not very sure that it will work as the regulators have expected. Now I would like to give the floor to all of the speakers that have to answer the questions that have been raised. The questions are addressed to specific speakers. Of course, there are some questions that are addressed to Professor Ellul, who had to leave.
I think I can help with that one, though, because it also touches upon my
I would suggest to start with your own questions, and I would like to give the floor. I'm not very sure if there's a question for Dan, or as far as I can see. There's some questions for Mireille, for Mrs. Caruana, and there are some questions that are not addressed to specific speakers, but I would suggest then that Mireille could try to answer the question. I'm sure that she can do it very effectively.
Hi again. Well, I'm not so sure, because I was asked what is the legal basis that companies are using. Well, no, I mean, I don't know, because I don't know if there are companies of the sort, at least, that are, let's say, trying to be in line with the GDPR. What I would say on this front is that there's a lot of discussion around Article 9(1)(e), I believe, right, which is a legal exception for processing sensitive personal data, which is manifestly made public. Now, the court has interpreted this ground very narrowly, so it doesn't seem like it's going to work, which is why I said that in the end, I think that any such system will be found to be in violation by a DPA, I expect, even though, of course, the specifics perhaps always come into play. The court has always said that when it comes to lawfulness, you need to, and it's sensitive personal data, you need to apply Article 9, Article 6, for those who are familiar with GDPR, and Article 5, the general principles. So my only question about interpreting the law and how it might be applied in future is my thoughts around the idea of fairness and reasonable expectations. If we read Article 9, Article 5, in light of this core principle, maybe, I mean, I think one could make an argument that Article 9(1)(e) should apply. I just don't think it would be accepted today, at least. And I wonder if that's flexible. Or as I said, or maybe eventually, of course, social norms change with time, and perhaps laws also eventually will be updated. Unless we keep, of course, agreeing that scraping facial images from the internet is as simple, like something we want to absolutely prohibit. And the question carried on by saying about law enforcement. Law enforcement, yes, indeed, of course. It's well known that in the EU, law enforcement has its own directive. What I can say about this is that when the ICO in the UK were investigating Clearview AI, they first fined the company and found them in violation. It was appealed, and the tribunal reversed that judgment on the grounds that Clearview AI were servicing law enforcement abroad, and that therefore was a matter of territorial sovereignty, and that the UK should have no jurisdiction. To my knowledge, at the moment, the ICO has appealed this judgment, saying that Clearview AI themselves are not law enforcement, that they are a company. So I think we are still awaiting a judgment on that, like the appeal from the ICO being the Detection Authority, right, in the UK, the appeal for the ICO's office. That's what I can say, I think, from my perspective on this question. But thank you very much for the question to the person who.
Thank you, Mireille. I can read some more questions, but I'm not very sure who is expected to answer. There's a question about legal personality and AI subjects, which is addressed to all speakers. Or there's another question, I'm not sure, but about for Professor Ellul, which could be replied by Paris or Ioannis?
I think I can give it a go. It is the question of Mrs. Longitidou, who asks whether the AI Act can help with assurances, and how easy is that going to be in view of the fact there are so many ISO and other standards out there, and that might create a certain degree of confusion. And I agree to a certain extent with the premise of the question. Nobody really knows how exactly compliance is going to take place. The AI Act right now is referencing industry practices from an industry that has just been formed, which means that there are not really concrete ways of doing certain things. For example, Article 9 says that we need to have a risk management plan, but nobody really knows how to write such a risk management plan for an AI system. And the same applies, I can say that definitely for the duties referring to general purpose AI models, right? But especially if I use the example of general purpose AI models, my feeling is that the legislator is hoping that codes of practice will come up from the industry that will help with compliance with the assurances under the supervision of the AI office and the authorities, which kind of gives me the impression that we are building the plane while we are flying it up to a certain degree, which is the risk. What happens when a legislator interferes when the business models are not clear? And, you know, there is a certain degree of uncertainty on how to do that. I could go on and say the same for all the other obligations, but one last comment on this question. One of the issues that Professor Ellul raised was cybersecurity, and he was very adamant about that, and I agree. But if you look at the EU AI Act, cybersecurity is only an obligation for high-risk systems and for general-purpose AI models that pose a systemic risk. And I ask, ChatGPT and the usage that I made in order to create Péter the raccoon looking like the Pope, is cybersecurity not necessary for that? I don't know. I would consider it to be necessary. Nonetheless, the legislator did not feel like expanding this obligation for these systems. Maybe it might be covered by general cybersecurity obligations, but in any case, the premise of the question, I agree with that, you know, assurances is going to be a long trip.
The examples that you have mentioned in your presentation, Ioannis, was really have proven that what Mireille has mentioned, that the use of such systems may constitute a kind of threat for democracy and may undermine the democratic structures. Of course, the case with Raccoon is something for personal fun. It's not where the AI Act will be apparently not applicable, but the use of such deepfakes to disseminate deepfakes or misinformation, of course, there will pose a great challenge for democracy also, not all, simply for the law. Is there any, there is another, the question posed by Stefanos Mitropanos concerning the imposing sanctions against AI subjects. That means this kind of legal personality, recognized legal personality to AI systems, models, whatever. Is there anybody that would like to respond to this question or to comment on this question? Or I must say, I don't like the discussion about legal personality because I'm not feeling so well in the context of civil law, but I think that is it's interesting that this question is appears again and again, and it's a way to discuss also the issues of liability. But in my view, if I can take also a position on this, it is not acceptable to shift the responsibility to a machine and liability and impose sanctions on such a kind of legal personality. I'm not the expert that could give an adequate response to this question, But if anybody else wants to add a comment or to share a thought about this. Nobody is willing. At 8:30, and after 3 exciting hours, and then it's 4:30 in Australia. Okay, and I think that after 3 hours of this exciting discussion, and I have a lot of questions concerning sharing of presentations, video, etc., but I'm not sure that I can answer these questions. I would like to thank you all. Perhaps Paris would like to add something, or Mireille from the part of the universities that have organized this webinar. Nothing. Paris is Mireille, something to add?
No, I was just going
except of saying good night to Dan.
As you have rightly said,
putting him into
the real, I think, glue between us today has been Ioannis. So I'm fronting the department sort of, but in reality, as we have said, it is his efforts that have brought us here. And it's been such a pleasure, is my comment. And thank you so much.
For me also, it was really a pleasure to have participated to such an exciting webinar. Thank you for the honor and the invitation.
Thank you. Thank you, everybody.
Have a nice evening, night.
Thank you. It's been great. Thanks for inviting me.
My God, I can't believe it's 4 in the morning then. Great.
Yeah.
Thank you once more, Dan.
Bye-bye.
Thank you.
Bye. Bye. Thank you. Bye-bye.